Mr. Wyatt, you've had a chance to review your exhibits. The requested exhibits have been received. A was marked but not requested to be received. Is that your understanding?
We tried to admit it on 2 occasions, Judge. That was denied by Your Honor, so yes.
So it was not received?
It was not received.
That's right. But all your other exhibits were received?
That is correct.
All right. Are you calling any other witnesses?
No, Your Honor.
And you're going to rest?
Yes, Your Honor.
All right. Do you wish to make a motion? For Rule 29 was referenced.
I do, and it would be exactly the same additional motion that I made at the arresting the plaintiff's case, Your Honor, the prosecution, with the additional evidence that Your Honor has heard now, given the context of that. I don't need to reiterate it, Your Honor. Your Honor, sitting right there, you see the video, you see the testimony and the expert testimony, and again reiterate that the prosecution, there's no reasonable jury to come back with that particular verdict as to the particular charge of murder or complicity in murder.
All right. Thank you, sir. State response.
Judge, the expert testimony was speculative at best, with concessions that the doctor actually was not aware that some of the medications that he was opining impacted the injuries were actually provided at the hospital. So he authored a report and provided some testimony without all the information, and I don't know that everything that he said can be taken seriously per se, because he didn't have all the information available to him. And that was pretty evident during cross-examination, and that deals with the issue of causation. We've still proven for the same reasons that we articulated in the original Criminal Rule 29 that the defendant has committed the offense of felonious assault and murder, and we'd ask that the Rule 29 motion be denied.
All right. Thank you. Anything further, Simon?
There's just one point as to the expert. The expert was absolutely on point. He was not thrown off. He was found credible, in my opinion, and he absolutely no reason to discredit this particular expert that said absolutely that this particular hits by this particular defendant could not have caused the death of Mr. Vesquez. That's it.
All right. Thank you. Well, the question is not that the state is asking that the Dr. Rapp's testimony be stricken. It's really in your motion for a directed verdict or a motion for acquittal under Criminal Rule 29. The state has a burden of production, which the court has already found that they did meet at the last motion, which was at the conclusion of the state's case. I'm looking at the evidence in a light most favorable to the state, because that is the standard of which the court must decide. As I consider the evidence as presented by the defense, the 3 witnesses and their testimony, I do not find that there was anything that would change the court's prior ruling. In other words, the state has met its burden of production as to evidence as to each and every element of the offense that, if believed by the jury, could support a finding of conviction. Now, that is not saying that that's what the court is deciding. It's just that in this situation, they have provided sufficient evidence to continue on with the case so that the trier of fact can actually consider the evidence. The coroner's testimony, the assistant or deputy coroner, provided a testimony that at best is contradicted by the expert for the defense. Therefore, that makes it an issue of fact. It is not for the court to determine at this point which witness to believe. That is in fact for the jury. So the evidence has been received, and it will, the Rule 29 motion will be denied, finding that the state has still sustained its burden to proceed. With that, the state, and this goes into exhibits that were not admitted, you do have the rebuttal case. I don't know if you're calling a rebuttal witness or not, but it is with the state for rebuttal witness.
The state does not plan on calling any rebuttal witnesses, Your Honor. We do not intend to.
Right. So the state has rested as well. That will be the conclusion of the receipt of evidence by the court. We can then move on to whether or not there is sufficient time to close the case to the jury. It is now 2:30. We have roughly 2 hours. That would be close to an hour for each side, which would seem to be, to this court's opinion, enough time to close out the case by closing arguments. I would then instruct in the morning. The only part that I have that may still be of concern for you is just exactly which instructions is the court going to give so that you can structure your argument. I can indicate that we have already indicated over objection, but with the modifications, the consciousness of guilt instruction. We have also given the expanded causation instruction, which the court has given the pertinent Ohio jury instruction subsections that apply to this case. I would instruct the parties to read those expanded versions so that closing can be consistent with the instruction as given. And there may be objection, and that will be noted at the appropriate time. However, causation has been expanded to include all those which were pertinent in OJI. There was a continued question about whether or not the court would be allowing self-defense instructions both with and without deadly force, as they are labeled within the case law and within the jury instructions. The court is selecting in this particular unique situation to allow instructions for self-defense both with and without deadly force. I do read the case law to indicate that the court in this particular fact pattern is instructed to give those instructions. The case law provided by the state, specifically the case versus state v. Pool, is somewhat a different situation. And in this case, the defense goes something more like this. I am claiming self-defense, and without objection, I've indicated through the questioning that I did strike Mr. Vasquez during this incident, but I maintain that it was in self-defense. If with that, there's also still the burden of proof upon the state, which does have the burden of showing causation. It makes perfect sense to the court that within the self-defense instruction, they can still indicate, yes, I struck the individual, but my striking of the individual, even though I was doing it in self-defense, was not the cause of the death. Whether or not the jury is persuaded by that argument, that is for them to decide. However, the court is interpreting the case law as read, that it is in the best interest of the fact pattern that we have here to instruct accordingly. That would be over the objection of the state, and so noted, but that is an instruction that should be given. The last part that I have to address is whether or not there was on the lesser included. The court has revisited several times, and Mr. Ayat, I know that you are bringing up again that you would like to have the involuntary manslaughter with the basis being simple assault instructed, which would be the felony of the third degree. The court has reviewed all its notes and is going to decline giving that instruction. Objection noted. That leaves us with the lesser included of whether or not it would be voluntary manslaughter or involuntary manslaughter. I ask the parties to discuss this because the voluntary manslaughter within the statute itself indicates the provocation by the victim. And you should highlight the word victim because that's where the provocation has to come from, the voluntary manslaughter. And if you have to identify who the victim is here in this case, I think both parties would agree that Mr. Vasquez is the victim in this case. So the parties agree to that.
We do, Your Honor.
You do, Your Honor.
All right. So that is part of the qualifications, whether or not it is going to be a provocation, involuntary manslaughter brought by the victim, or in the involuntary manslaughter with the underlying charge, as the parties have indicated, being aggravated assault, which has the same language regarding provocation, once again by the victim, whether or not that is the appropriate instruction. The parties had an opportunity to discuss this amongst themselves, or is this still up for argument for the court to decide?
Judge, we did have the discussion and we still have a disagreement, which is not surprising. I had agreed with Mr. Ayad, and obviously I initially filed the request for an instruction on an offensive and inferior degree or a lesser included offense. The problem with involuntary manslaughter is it requires a felony outside of felonious assault. Because if we use felonious assault as a predicate offense, then it wouldn't be a lesser included offense of murder. Okay, so we need to find a different felony. In order to get to that, we had discussed using aggravated assault, which, as the court has already indicated, pretty much has the same language as voluntary manslaughter with regard to provocation. Now, I'm not going to get into the nuts and bolts of provocation because Mr. Ayad and I will never see eye to eye on that, so there's no reason to go down that road. That's not necessarily the issue. I think provocation can be an issue, but the bigger issue to me is the fact that the provocation results in the use of deadly force. Now again, I'm not withdrawing a request for a lesser included because we agreed to do it, but the problem is, in order to get a lesser included, in my opinion, for either voluntary manslaughter or involuntary aggravated assault, there would need to be some sort of concession that deadly force was used. And up to this point, Mr. Ayad is not willing to make that concession, which is why he asked for the non-deadly force self-defense instruction.
I'm sorry, up until this point, Mr. Ayad
has not conceded that point, which is why he's requesting the non-deadly force self-defense instruction. So I think we have an argument that continues to go round and round in circles, and I don't know how we fix that based upon the defense theory of the case.
Judge, well, we can fix it by adding the additional involuntary manslaughter third as the simple assault, Judge. That I think we feel that there's set of facts where the jury could come back and say, yeah, there's just kind of a simple assault. Now, whether they find additional aggravated assault, that's again for the issue for the jury to decide. Again, Your Honor, the state brought these charges. We feel we're entitled to lesser included offenses. We filed motions on these issues. We feel very strongly that we should be entitled to the simple assault, lesser included offense, because that's really what happened. If someone punched a punch, which is a misdemeanor, no weapons was used, and ended up death, and that's exactly what the division is envisioning. Involuntary manslaughter, third degree, under the Ohio rules. That said, Your Honor, as to the provocation, we definitely feel there's provocation by both Mr. Richter and Mr. Valdes. He testified clearly. He was never asked to be touched by Mr. Valdes on a number of occasions. He kept coming at him, coming in his face, coming at, grabbing him a few times, Your Honor. In that sense, I think that satisfied the basis of provocation. I mean, if someone touches you, you never told him to touch you, that's provocation, much less than words, but it's a definite action, it's an unwanted touching.
Judge, I'm not arguing that's something we can argue for in front of the jury. My issue is the deadly force component of each of those. I'm not saying that he shouldn't get a lesser included offense, but the problem is you can't argue the use of deadly force was warranted based off of provocation for a lesser included, but then...
I apologize. Can you... shouldn't get to the lesser included offense, and then
It's difficult to argue that the lesser included offenses are warranted through the use of deadly force when you're not willing to concede that deadly force was used. So I don't have a problem with an F1 lesser included offense, I just don't know how to get there. That's basically what I'm saying.
Yeah, no, I agree wholeheartedly with Brother Counsel on this. I mean, these are some of the elements that they have to prove. They still have to prove those elements, Your Honor. And I think that the jury still may find that there was deadly force. That's not up to me or Brother Counsel to make that determination. It's one of the elements that they have to prove on the lesser included offense. So I think there is obviously clear evidence to substantiate that lesser included offense to be included in this particular case for the jury to consider. We can't sit here, stand here today, Your Honor, and say that the jury is no way, no how, shape, or form going to be able to come to the conclusion that it's deadly force. They still could find deadly force, and they could find that it was done on the basis of provocation and give him an involuntary first, Your Honor.
I just indicated a few moments ago that I am also giving the non-deadly force instruction. So that's no longer on the table. So we don't have to argue about that. What we're arguing about, and what you want, or what I'm hearing your arguments about, is which lesser included. Now, the lesser included for the F3 based on simple assault. And we went over this on the record. The elements for simple assault: cause or attempt to cause harm to another. The elements for the felony charge of assault: knowingly cause serious physical harm to another. What happened here, and what the court sees as the evidence, and what is stated by the defendant is he knowingly, if the jury believes that this would be the argument, punched an individual in the face. He says for self-defense, which is fine. I'm giving that instruction. I think it's warranted. And you know, giving the self-defense instruction in this case, and still arguing cause, is a little bit of an unusual finding consistent with Ohio case law, but I still find it appropriately warranted. But with that then goes to the question of whether or not there was the serious physical harm. And what is readily apparent from what happens on the videotape is from the last strike, there was no movement forward. Okay, Mr. Vasquez never moved. All right, so the serious incapacity of the victim is right there, right then, which is part of the definition of serious physical harm, which is part of the definition of felonious assault. It's not that he struck him and caused injury or attempted to cause injury. It's he knowingly said he did, punched him, and that punch causes no more movement. And the testimony clearly indicates, and your expert witness does not counter this in any way, shape, or form, he never regains consciousness. That's the serious incapacity. Now, it also includes death 4 days later, but it does have that right there. Upon connection, boom, immediate result. Therefore, the court is allowed to be the gatekeeper of what the charges are based on the evidence presented. There was no evidence presented that this was a simple assault. All of the evidence shows that this was a knowing strike that caused serious physical harm. I cannot give the instruction. That's my opinion. Your objection is noted. We're not going to argue about that any further. Thank you.
Judge, can I
This is a closed issue, sir. Understand that. That's where you get to say, if I need the Court of Appeals, your record has been built. Make your next argument over there, please. Thank you. All right? We just have to move on. It is done. I gave you the same answer yesterday. I'm completely consistent with the answer again today. You know the position. That's it. We're there.
Yesterday, the testimony of the expert wasn't there, Judge.
And the testimony I just told you didn't change anything today. I'm not going to engage in a one-on-one argument with you, sir. That part is done. So, it comes back to the question I asked you just a few moments ago. Please, gentlemen. Have you decided in unison whether or not it's going to be a voluntary or an involuntary? Just like I said a few minutes ago, that's the only issue left. All objections noted.
I guess then I'll just put forward voluntary.
But by these rulings, Your Honor, we'll go with it, I guess. That's what we have to roll with.
I'm sorry, I didn't hear you.
We'll go with it. That's what we have to roll with.
The lesser included will be the voluntary manslaughter. We are modifying the instructions at this point. We're going to take a short break so that I can show you the instructions on causation that have been added, which, quite frankly, is right in the OJI. It's just a further recitation of what had been argued for natural and foreseeable consequences. With that, we'll be in about a 5-minute recess so I can show counsel. All right. So, we'll take a break from that. Step out back towards the jury room and see if they can do with them.
Judge,
Do that.
so it's complicity still on, I just want to make sure.
Yes.
And voluntary, complicity and voluntary.
It's going to be voluntary, but not involuntary. Only
Complicity as to both. Complicity as to both.
Yes.
Just put it in right now, Judge.
Right. I'll just say, I'll try to step away and try to give you as much of a break as I can going into this.
I know.
And counsel, if you guys could both be conscientious about the case at which you're speaking, I would also want to give a glance to our report and make sure we're doing that. All right, you may be seated. Ladies and gentlemen, outside of your hearing, the defense rested their case. Correct, Mr. Ayat?
Yes, Your Honor. That's correct.
And all of the defense exhibits were received, and the state has selected not to put on a rebuttal case. That means we are at the point of closing by the parties. We will then retire for the evening, and instructions of law will be given to you tomorrow morning. So we will have you returning tomorrow morning for your services, but we are going to go ahead and finish off with closing arguments. So the state has the burden of proof. They're obligated to go first, followed by the defense, and then the state is allowed to give a rebuttal argument at the end. Mr. Spartak.
Thank you, Judge.